Consequently, the slaughterhouse cases of 1873 wholeheartedly agree with me. And then it happened. The massive abuse of our 14th Amendment Birthright Citizenship Clause amped up in the late 1900s, where there was no law passed, no motion granted, nothing, just a targeted group of foreign nationals not lawfully present in our country locked themselves into targeted holes of records where they had people waiting. I'm going to open this up by saying that although I have worked for law offices before in the past, I am not an attorney. I'm just one heck of a researcher. Now, people, what if the 14th Amendment Birthright Citizenship Clause actually ended a long time ago, long before Wong in 1898? The phrase of today is cessante ratione legis, cessat lipsa lex. And that translates to, whether I said it right or wrong, when the reason for a law ceases, the law itself ceases. I'm arguing that the 14th Amendment was a remedial provision, a one-time correction for a specific group, rather than a permanent, self-executing machine for all future generations. Here's how that dead law or spent law argument breaks down in a constitutional context. 1. The remedial versus permanent debate. The remedial view. I'm arguing that the amendment was a bridge. Once the recently freed people and their immediate children were secured as citizens, they became American citizens under the original Constitution. Their grandchildren wouldn't need the 14th Amendment Birthright Clause because they would inherit citizenship from their now citizen parents via jus sanguinis, right of blood. Under this view, the clause fulfilled its mission and should have become inactive or spent. The permanent view, the courts. The Supreme Court has historically treated the 14th Amendment as a foundation, not a bridge. They argue that because the text says all persons born, and not all persons now born, it created a permanent standing rule of the land that applies every day, regardless of whether the original reason the freedman status has been addressed. Concept, D-E-S-U-E-T-U-D-E concept. In law, desuetude is the idea that a law can lose its binding force through long-term non-use or because the conditions it addressed no longer exist. However, American courts almost never apply this to the Constitution, though they should. They argue that a constitutional amendment can only be killed, quote-unquote, deleted, by another amendment, Article V. My counter to this is that I can argue that the law isn't dead because of non-use, but because its legal target, the transition from property to citizen, was completed. Using it for anyone else is like using a medical emergency permit to park at the grocery store long after the patient has recovered. If I were to sum this up for our community or anyone listening, the 14th Amendment was a reparation of status for the freedmen. It was a specific key made for a specific lock. Once that door was opened and our ancestors walked through to become full citizens, that key's job was done. The government didn't throw the key away. They started using it to let the whole world in, effectively changing a private inheritance to a public sidewalk. And then it happened. The massive abuse of our 14th Amendment Birthright Citizenship Clause amped up in the late 1900s, where there was no law passed, no motion granted, nothing, just a targeted group of foreign nationals not lawfully present in our country locked themselves into targeted holes of records where they had people waiting and applied for birth certificates, leaning on the Wong decision, which in itself had zero to do with non-permanent immigrants and certainly not illegal immigrants. I know, because I was there. Consequently, the slaughterhouse cases of 1873 wholeheartedly agree with me. We are told to wait and be patient while our amendment is used to prioritize people who have no historical claim to the Reconstruction struggle. This isn't just an immigration debate. It's about the theft of our legal standing in the nation our ancestors built. Some key historical fact to support my speech. In the 1866 debates, Senator Jacob Howard explicitly stated that the amendment did not include persons born in the United States who are foreigners, aliens, or who belong to the families of ambassadors. This quote is powerful because it proves that the universal interpretation used since 1898 was actually rejected by the men who wrote the words. Ain't you tired? Wake the F.
You're the writer of life, let the story begin. Wake up! Wake up, wake up, wake up!